Well, good morning, everyone. Sorry to be a little late starting. We've had a bit on our plate this morning. Welcome to you today to this briefing, JMA, on the mandatory matters. This is the second in a series of sessions on the proposed joint management agreement between Taupō District Council and Tū Wharetoa Maori Trust Board. Today's focus is on the district plan and resource consents in the mandatory matters for the joint management agreement. Additional briefings will follow in coming months on other key topics. This is an information sharing phase with any decisions still some months away. All councillor briefings, including today's, are being live streamed to ensure openness and transparency. The joint management agreement is required by legislation and is an important step in how council works with partners and the community. The session gives everyone the chance to understand the framework, implications and next steps. A reminder that in line with normal meeting processes for council briefings, questions can only be asked by councillors. That's why it's important that you stay in touch with your councillors and ask them to ask your questions and to keep them informed of what your position is. I now hand over to the Chief Executive, Julie Gardine.
Good morning, everyone. Actually, it's my pleasure to introduce the team for today. So today we've got council staff that are presenting on the mandatory matters. So I'll hand over to Sue, Nick and Heather, and they can perhaps introduce themselves, even though they're familiar to you. There's members of the public and obviously people watching on a live stream. So my pleasure to hand to them, and thanks for the work that they've gone for today's briefing.
Morena koutou. Ko Sue Mavor toko ingoa. My name's Sue Mavor. I'm in the iwi and co-governance team, and I have with me Nick Carroll, who's the manager of the policy team, and Heather Williams, who's the manager of the resource consent team. We are going to go through today some of the mandatory matters, i.e. the matters that must be included in any JMA we have with the Tū Wharetoa Māori Trust Board. We're not going to call them mandatory matters, we're going to call them compulsory matters because we thought that was a little bit more straightforward and a bit clearer. We've only got time to cover some of those mandatory matters today, so we're not going to do all of them, but rest assured we will do the other mandatory matters in the next workshop. We want to make sure there's enough time for questions. So what we will do today is we will outline two sets of compulsory matters, and that is, three sets. So we will outline the extent the JMA has to cover, the geographical extent. We will outline the plan change process and the resource consent process that's required under the legislation. We will provide some examples, and most importantly, we will answer your questions. What I'd like to do is hold off questions until we have a break in that presentation. Now, it's really clear. It's after slide 11, after Nick has finished speaking, and there's a slide that says question. So that's your cue. And then after Heather has finished her section on resource consents, there's another slide that says question. So again, that's your other cue. So if you could hold them till we get to those points, that would be really helpful. Just a word of warning, the legislation is quite complicated, and I'm sure some of you will have delved into it and had a good look at it. The wording isn't the simplest, and you'll note that in the draft JMA that we drafted last year with Tū Wharetoa Māori Trust Board, we tried to simplify those compulsory matters into clear processes that must be followed. Now, the reason we did that was to make sure that everyone is clear about what's required and what we've agreed to, even when we're gone. You'll remember that in the first information session, just before Christmas, Paul Beverley spoke to us about the settlement between the Waikato River iwi and the Crown over the Waikato River in 2009. That settlement, he explained, resulted in the Ngāti Tūwharetoa, Rokawa and Te Arawa River Iwi Act in 2010. All the way through this presentation, we will refer to that as the Upper Waikato River Act, just because that's a little bit shorter than its official title. That settlement, you'll remember, put in place a number of actions to restore and protect the health and well-being of the Waikato River, and that was done for future generations. There are a whole raft of actions that need to be implemented from that piece of legislation. And they're all put there because it was believed that they would, once implemented, be able to protect and enhance the Waikato River. One of those many actions is a requirement for all councils in the catchment of the Waikato and the Waipa River to have joint management agreements, which is a legal agreement, with their river iwi. So it's not just this council that has that requirement, it's all councils in those catchments. Now the purpose of that JMA, the reason that was put in into the settlement legislation, is to ensure that councils and iwi work together to ensure that the council's existing RMA powers and duties protect and restore the Waikato River for current and future generations. So it's not something we can opt out of. You'll be aware that we already have 2 JMAs under this settlement legislation. One with Rokawa that was signed in 2013, and one with Te Arawa River Iwi Trust that was signed in 2017. Obviously, these have been in place for a number of years. The Upper Waikato River Act sets out what the compulsory matters are that any JMA must cover. Most of them require the Trust Board's involvement in council processes around matters under the RMA. So things like district plan changes, monitoring and enforcement, resource consent processing, and enabling customary activities. We're only going to talk about 2 of those matters today. The rest we will talk about in the next briefing. Essentially, the reason for this is about formalising the early involvement of the Trust Board in these processes under the Resource Management Act. There's another mechanism, well, there was many other mechanisms that were put in place through that settlement legislation, but another one that I'm going to talk about today, because Nick will talk about it later, so you need to know a bit of the background of it and what it is. It was essentially embedded through the Upper Waikato River Act, is the vision and strategy for the Waikato River, Te Tori Whaimana. This essentially is the primary direction-setting document for the Waikato River and activities within the catchment. It's about physical restoration and the protection of the river. And it's about the restoration and protection of the relationship between river, iwi, wider community, sector and industry resource users. It's essentially a long-term blueprint for restoring and protecting the health and well-being of that river. Every council within those catchment of those 2 rivers, the Waikato and the Waipa rivers, is required to give effect to the vision and strategy through their resource management planning processes. So district plan changes, resource consents, monitoring and enforcement, as are we and have been since it was put in place in 2010. There's one other thing that I wanted to draw to your attention, and that is there's a series of principles in the Upper Waikato River Act, which are about how both the Council and the Trust Board should behave and work together through developing the Joint Management Agreement and implementing it. That's in section 46, if anyone wants to look it up, but it covers the sorts of things that, to me, are fairly obvious. So it's things like working together in good faith, and the spirit of cooperation, being open, honest, transparent, and using our best endeavours to ensure that the purpose of the Joint Management Agreement is achieved and in an enduring manner. So there's a series of principles that we just keep in mind while we're doing this work. So the first compulsory matter that I wanted to cover off is the geographical extent that the JMA is required to cover under the Upper Waikato River Act. It is essentially the catchment of the Waikato River, and the catchment of the Waikato River as within our district is shown there on the screen. The area starts from Te Toko Atia, which is just north of Hooker Falls, and follows the Waikato River until it exits our district and moves into the district to the north, which is just on the north western edge of the district. So that blue area is the compulsory geographical area that the JMA must cover under the legislation. Just so you're aware, many of you will be, because you know that area well or you live in that area. It's essentially a rural area with some small settlements, so Mangakino, Whakamaru, Aotearoa, and a small piece of industrial land at Rakanui Road. It's not an area that comes under great development pressure, and so hasn't had loads of plan changes over the years, or hasn't had a lot of pressure for resource consent applications over the years. I'm now going to hand to Nick, who's going to talk through the compulsory matters for district plan changes.
No, you're all good. Thanks, Sue. Today I'm going to try and walk a little tightrope between the technical language that we operate in under legislation and when we're conducting our RMA processes, our Resource Management Act processes, and the language that is actually comprehensible to the rest of the community. So apologies at times if I slip off one side of the rope and get a little bit technical. I hope you'll pull me up and ask questions. And certainly when we're trying to simplify, and we're not trying to dumb down the messaging, we're just trying to make things clearer in terms of the compulsory requirements in the legislation. There were just two key points I wanted to make before I sort of jump into the discussion around the district plan. The first is around the little elephant in the room, which is the change to the planning system. So we've had the Resource Management Act in place since 1991. And it's set up a planning system which has enabled us to manage resources. That's going to change. The government is clearly going to repeal the RMA and replace it with a couple of new acts, and we're expecting that to be in place around the middle of the year. Just to be very clear, even if that system changes, the Upper Waikato River Act is not going to change. So the compulsory requirements that we're going to talk about today in the context of district plan changes and resource consenting will remain under the new planning system. How they're expressed, how we operationalise that will probably change. We'll have some new jargon to use, and we'll have some different processes that we'll have to apply, but the obligation to give effect to the Upper Waikato River Act will continue under the new planning system. Second point I just wanted to make is that there can be a tendency to look at the Upper Waikato River Act and imagine that the river iwi are being given a greater opportunity to be involved in these RMA processes than the wider community. That is the case. That is the legislative intent that flows through the Upper Waikato River Act. And that's why you see through these processes that we'll talk about a clear role for the Trust Board in monitoring, enforcement, district planning and resource consenting. So I just wanted to touch a little bit on council functions. Because the legislation, the Upper Waikato River Act, is a little bit odd in that it refers to council, and when it does so, it's only referring to the Waikato Regional Council. In the legislation where it talks about territorial authorities or local authorities, that's when we come in. And this is important because much of what's sitting in the legislation actually applies to the Waikato Regional Council and its functions. So the Regional Council's functions are primarily around sort of the environmental elements that we're used to managing. So things like the air, soil, the water, looking after pollution that occurs, managing the coast. And management of water is really at the heart of much of what the Regional Council does. That's why they're the authority that grants consents for taking water and for discharging into water or discharging onto land. We, on the other hand, have functions under the RMA which are primarily about the land and how it's used, where buildings are located, where land can be subdivided, provision of infrastructure, management of growth, management of natural hazards. So the consents that we grant, the functions that are relevant for TMTB and to us in the context of this JMA, are around land use consents and subdivision consents. This slide is just pulling out the three key elements which fall out of the JMA in terms of compulsory requirements. And they reflect, I guess, the basic planning cycle that we go through when we're doing resource management work. Starts with monitoring, where you're identifying issues that need to be addressed. You then flow through into changing the district plan as it currently sits under the RMA, to put in place rules or policy direction to try and address those identified issues. And then the likes of Heather's team comes along and manages that on the ground through resource consent applications, where we can look at things on a case-by-case basis, trying to achieve those overall objectives. And then we monitor how effective that's been, and then we come back and we make further amendments. So there's this constant cycle that goes on over many years, actually, trying to deal with emerging resource management issues. And the Upper Waikato River Act is about trying to create, I guess, a process for TMTB to be involved in those three different elements of the work that we do as a council. So Section 48 of the Upper Waikato River Act talks about how TMTB will be involved in district plan work that we do. But you'll see in that first bullet point, we're talking about either preparing, reviewing, changing, or varying the district plan. Don't get too hung up on what feels like 4 different words to describe exactly the same thing. They're essentially just different terms that reflect the way that you change the district plan at different points in its life cycle. Importantly, the district plan changes that we're talking about under this piece of legislation must relate to the vision and strategy, which is sitting at the back of the Upper Waikato River Act in Schedule 1. And I'd suggest you go and have a read if you haven't had a chance. It essentially sets out a vision for what we as a community want the Waikato River to be going forward, and the relationship that we want our communities to have with that river. So when we're doing district plan change work, we're thinking about how does the change that we're making to our district plan actually impact on the vision and strategy. Importantly, all of the next slide that I'm going to talk about is in relation to changes to the district plan that council makes. And most of the time when the district plan is changed, it's driven by council. There are opportunities for private individuals to make changes to the district plan as well. And we'll cover that off in a couple of slides' time. So, very simply, at the start of a process where we're looking at changing the district plan, the legislation, the Upper Waikato River Act, requires us and the Trust Board to sit down and form a little joint working party at an officer level. That working party then has a couple of jobs to do. It's got to make some recommendations up to council. as the decision-making body. Firstly, it's got to look at the process that we will work through to develop a district plan change. And every plan change is different depending on what it's trying to address, the issues it's trying to grapple with. That often means that it's impacting different parts of the community in different ways, or geographically different parts of the community. So we never have the same process that we apply every single time. Secondly, that working party's got to have a look at the basic form and content, and those are the words that are used in the Act, the Upper Waikato River Act. Essentially what that means is we've got to look at what are the issues we're trying to address, and what are the options that might be on the table to try and address those. Second recommendation is around whether council has enough information to kick off the process and make an amendment to the district plan. And then the third recommendation is around the version that we will go out and talk to the community about, that we will notify and ask for submissions on. At that point, after council has made a decision about whether to proceed and the form of the plan change that it's going to proceed on, we then move into a phase where TMTB steps back and they would have an opportunity to become a submitter to the process if they chose to. It's probably really important to point out at this stage that plan change work is never done in isolation. So I've talked about how we will work with TMTB in the development of a plan change, and that's set down in the Upper Waikato River Act. However, we're also talking to groups in the community, we're talking to other iwi partners, we're talking to regional councils, we're talking to Crown agencies. We talk to a lot of different people who have an interest in the plan change work that we're doing. The last point on there is a requirement for council and the trust board to have a conversation, and it is simply a conversation about whether it would be appropriate for the trust board to have some involvement in the hearings panel process. So typically, once council's decided on a draft plan change and it's agreed to go out and ask for submissions on that, our typical process is then to set a hearings panel in place who will hear all the submissions and then make recommendations back to council. And certainly over many different plan changes we've had over the last decade, we've often had a commissioner who's got iwi experience or knowledge of those particular cultural values and tikanga involved in those hearing processes. Private plan changes. So all the last lot of stuff was about council initiated plan changes. There is the opportunity for private individuals to make an application to council to make a change to the district plan. And that's done through a private plan change under Schedule 1 of the Resource Management Act. Again, that private plan change has to relate to the vision and strategy for the joint management agreement to be applicable. So if it's a plan change to create a subdivision which might be many tens of kilometres away from the river and might involve a few buildings or a small industrial site, chances are that that plan change is not going to relate to the vision and strategy. What we're required to do under the legislation is to talk to the trust board about opportunities for them to be involved in that private plan change application. It's important to bear in mind that in a private plan change application, it's the applicant who's driving the process, not council. We're very much responding to it, similar to we would a resource consent application. What the draft JMA does talk about in this context is the opportunity for council to connect a private developer with the trust board when we become aware of a potential private plan change application. There's also the opportunity for council to provide a copy of the application once it's lodged to the trust board. So those are a couple of examples of how council could put in place a mechanism for the trust board to participate in that private plan change process. So, quick summary. The Act, the Upper Waikato River Act, explicitly expects that the trust board will have a role in these plan making processes under the Resource Management Act. That happens right through the process, right from the very beginning when we're thinking about grappling with the new issue, all the way through to notifying a draft plan change for submissions. Council makes decisions all the way through, so that doesn't change as a result of the Upper Waikato River legislation. And importantly, the joint management agreement is about how we operationalise this. So the legislation sets out our requirements, and the JMA is intended to be, I guess, our guide for staff as to how we actually give that effect in reality. And that's why you will see that the joint management agreement's got pages and pages of clauses talking about often quite mundane steps about we'll agree this and then we'll meet then and we'll meet this many times. And it's about operationalising. So I'll pause there. Happy to take questions.
So Councillor Woodward is on the phone. So we'll start with Councillor Duncan.
Well, yeah, look, it's not so much a question for you, but and I appreciate the map, actually, because that's been useful, because that, just to actually clarify the area that's mandatory, we haven't really had that so clear before, so I appreciate that. Look, I want to point out, though, this is my personal opinion, that we didn't need to be here at all, and this could have been sorted out probably 12 months ago, I think, if elected members from the last term hadn't voted by reasonably slim majority to go beyond the mandatory matters to include this bone of contention extras, which is still to be clarified, I understand. Look, Councillors Taylor and Westerman are the two still present who were among those who voted for those extras to be included. So I suggest perhaps they are the best ones to explain to us all why they think we should be including them.
Councillor Hope Woodward.
I'm sorry.
Thank you, Your Worship.
I
just wanted to...
I don't like what Councillor Campbell's actually just put across and putting down the fact that he's trying to crucify effectively members that are still here. That's just not on.
It was a simple question, actually. This was a question. I'm not trying to crucify anyone. I'm actually trying to ask a question and get an answer, that's all.
Councillor Woodward.
Thank you, Your Worship. I just wanted to ask a question here. You've made quite a point just before even putting in a slide to point out the differences between the regional council's authority and what TDC does, or a council authority. I feel like this is a little bit of a way to deny accountability when it comes to things like water quality. And considering the upcoming reform, wouldn't it be better responsibility to take initiative to do the mahi that regional council does? Thank you.
Thanks for your question. The reason I put that up there was to make it very clear that under the Resource Management Act, there's a very clear delineation between the functions of district councils and regional councils, and that's to avoid duplication of effort and to avoid, I guess, confusion for the community. If we had two different councils managing the same function, we could end up with very different or mixed outcomes. So that's why the legislation is very clear about differentiating them. And as you've noted, the regional council has the primary function when it comes to water quality. That's not to say that our council doesn't care about water quality, and certainly we play our part in managing water quality, often we do that through the management of our infrastructure assets. You think about the way that we manage our wastewater discharges or our stormwater discharges. But when it comes to the Resource Management Act and the function of managing water quality, that fairly and squarely sits with the Regional Council. Now that may change through regional reorganisation, but until it does, that's the appropriate place for it to sit.
Councillor Cameron.
Thank you, Your Worship. It feels a very strange place at the moment because we're looking at not preparing district plans very soon, potentially. So we've put a lot of effort into the process we're going to follow under the district plan scenario, but we're now looking at a completely new act. Have we given consideration as to how this agreement would have longevity under that new legislation? I have follow-up questions too, if that's okay.
Yes, we've been thinking a lot about that, and I guess we're at a point where the Resource Management Act hasn't been repealed yet, and the Planning Bill and the Natural Environment Bill have not been enacted. We're expecting that to take place around sort of June. So as part of our workshop series, we're expecting to come back to you in July and to talk about exactly the consequences that will fall out of those new enactments and how it might change the way that we give effect to these compulsory requirements under the Upper Waikato River Act. The drafting in the Joint Management Act would clearly need to change, Joint Management Agreement would clearly need to change to give effect to that new legislation.
Because I also note that there, under the new legislation, there are more permissible activities as well. My concern is that we've got central government that's looking at amalgamation, regionalisation and potentially centralisation, and where does that leave this agreement in that case?
The Upper Waikato River Act is not changing, so these compulsory requirements will continue to be in place. How we give effect to them will obviously change with the new legislation, and we will talk through that with both yourselves and ultimately with the Trust Board. Sorry, I've just lost my train of thought. Yeah, sorry, what was the question again? Yeah, that's what I was hoping for.
The legislation, yeah. It's about the legislation, yeah.
We just,
Oh,
Yeah.
sorry.
Yeah, I'm just wondering how on earth these changes are going to affect the longevity of this agreement, because the current government has a very strong direction. To me, they're taking away our local voice. They're amalgamating, they're regionalising and potentially centralising. So where does that leave an agreement like this with internal processes and things like that?
We will still have a land use plan under the new legislation, which is sort of it's a alternative to our current district plan. What we will likely see is that new land use plan will have a lot more centralised direction. So we'll have a standard set of zonings that will come down from government. I expect we'll probably see some standardised provisions that will come down, things like yard space around buildings or the amount of site that can be covered will be set down as standardised rules. So what we will see is we as a council and the community will have less opportunity to influence some of those rules, which means that under the Joint Management Agreement, the Trust Board will similarly have less opportunity to influence some of those rules. But there will still be that planning process in place, and there will still be an opportunity for the Trust Board under the Joint Management Agreement to have a role to play in that planning process. It might just be less.
Councillor Greenslade.
Thank you, Worship. Thank you, Nick. when you look at the catchment, we back on to other councils, and the Turangi-Tongariro Maori Trust Board, of course, has JMAs with all of them under the Upper Waikato River Act. We're all different councils. What sort of relationship do we have with other councils in relation to this JMA?
Yeah, sorry, just to be clear, my understanding under the Upper Waikato River Act is that the Turangi-Tongariro Maori Trust Board only has a joint management agreement with us and with the Waikato Regional Council. They don't have one with South Waikato or Rotorua District Council, as an example.
So on the northern side of the catchment, what council is that on the northern side of the catchment when you look at the map?
South Waikato.
And so there's no relationship with the Trust Board and South Waikato?
That's my understanding under the legislation.
Okay. Yeah.
You've got to remember we've also got Tarrant and Rokawa, who
Yeah.
tend to sit in that northern part of our district.
Yeah.
So Rokawa, for example, have a joint management agreement with us under the legislation, but they also have one with South Waikato District Council and Rotorua District Council.
Right. Okay.
But because of the location of Turangi-Tongariro, they only have a joint management agreement with ourselves and the regional council.
Okay. All right. So the requirements in each different district council could actually be different according to the JMA that they have with them.
So you'll remember I said that the joint management agreement is an opportunity to operationalise these requirements. So what you will see is different councils will have different joint management agreements because they've decided to operationalise these processes differently with their different iwi.
Thank you.
Councillor Campbell.
Oh, yeah, look, I have a question, but it was half answered this morning, but I'll make a point about it too. How can we even be assured that Turangi-Tongariro Maori Trust Board represents the best interests of Hapu or even its own members? And I've heard it said by staff that, well, that's not our problem.
Through the chair, sorry.
Excuse me, you have to have a point of order reason. How about letting me finish my say, please?
Please
Councillor
proceed, Duncan
Devon.
Campbell.
But I would argue that actually is our concern. As far as I can tell, Turangi-Tongariro Maori Trust Board are a corporate entity with very minimal accountability to its members. They're certainly not covered by anything like the Local Government Act, which, although imperfect, at least keeps this council somewhat honest and transparent. And I look forward to a response, Nahuia, after. And if we are looking at examples of good governance, I don't think the management of 5 Mile Bay Recreational Reserve, which has now been under occupation for the past 5 years, is a very shining example.
Point of order, through the
why
chair,
should we
where
be
is the
partnering
question?
up?
Point of order, where is the question?
The question was actually at the beginning. I was saying that is not a shining example. Why should we be partnering up any more than absolutely necessary? So the question was...
Councillor Campbell, can you just pause there? I need to
Sorry.
get some advice on this.
So you're very supportive.
Councillor Murch, what is the point of order?
Looking for the question, relevance.
Oh.
Where is it?
So the question was at the beginning, but I was making a point. How can we be even assured that Turangi-Tongariro Maori Trust Board represents the best interests of Hapu or even its own members? I don't... Staff have said...
What's the relevance,
It's
Chair,
kind of relevant.
to the agenda item? That's the point of order. What's the relevance? Where's the relevance here?
Oh, well, the relevance is...
I'm not asking you. I'm going through the chair. Thanks.
Just pause, Councillor Campbell.
Look, if I'm going to answer that question, then it's probably not for the chairpersons. I think the team here are simply presenting what is in the Upper Waikato River Act. So if I draw you to section, I think it's 45 to 48, they are simply stating what's in the Act. That's up to the chair whether he determines that question relevant, therefore.
Councillor Campbell, I don't believe that question is relevant to the team that are here.
Well, through the chair, I mean, I'd argue, if we're talking about partnering up with anybody, I think taking into account how they function and what they actually are is kind of relevant, I would say. And I still await a response from Councillor Taylor and Westerman for my original question from before.
Next one is Councillor Hope Woodward. You have a question?
Thank you, through the chair. So we've had multiple agreements and statutory requirements since 2010 to restore and protect the Upper Waikato River, including the Act, previous JMAs and regional plans. What specific measurable improvements in water quality, like reduced nitrates, better MODI indicators or lower sediment, have we seen in our upper reaches from these existing agreements? If not much, how will this new JMA avoid being just another layer of process?
I think, as I noted earlier, the Waikato Regional Council has the functions around water quality. Certainly we could approach the Regional Council and ask for any monitoring results they may have or reporting that they have around water quality. I know they've spent most of that time trying to progress the Healthy Rivers Plan change to the regional plan, trying to set in place a set of targets and objectives and policies and rules related to water quality for the Waikato River. And that's intended to ultimately address the vision and strategies outcomes in the long term. But that's still progressing through the Environment Court at this stage. But certainly it's not this council's responsibility to deliver on that water quality improvement under the Resource Management Act.
Councillor Foreman.
Kia ora, Chair. Knowing that this agreement is a compulsory requirement, what are the risks to the council if we continue to drag our feet knowing that it's overdue?
I believe timeframes were discussed at the previous workshop, where it was pointed out that under the legislation there's an 18-month timeframe for the completion of the joint management agreement, unless the parties agree to take longer. And my understanding at this point is that the parties have come together and have agreed that they will take longer to deliver the joint management agreement, given that it was initiated, I believe, gosh, was it 2020? Yes. February 2020? So we're obviously well beyond the 18-month time frame. If one of the two parties decided to push the issue and say, look, we want to conclude this, and the other party wasn't ready to, then there is a process under the Act to elevate the decision-making through to the Minister. But I would suggest we're a long way from that at this point.
Councillor Leonard, do you have a question?
No, I don't have a question, but an answer to Councillor Woodward's question in regards to nitrogen reduction and things that have occurred through various partnerships. We do have the Lake Taupō Protection Project that was led by the Lake Taupō Protection Trust, and there was a 25% reduction in nitrogen into the Lake Taupō catchment during the details of that project taking place. The targets were achieved 15 years ahead of target. There's an entire website detailing that entire project and what happened there.
Thank you, Councillor Leonard, for that information. I do find that quite interesting, and I would like to, if you don't mind, guiding me to where I can find that information, because we're seeing quite a very high level of nitrates in the river.
It was an $80 million project that was joined together with government, iwi, Waikato Regional Council and Taupō District Council. It's a massive piece of history, and it is recognised internationally as well.
That's awesome, yeah, very, very good. Except currently our water quality doesn't reflect that.
The Taupō Lake Care Group met last week as well, within your ward boundaries at Marotiri, at the Marotiri Hall.
We'll move on.
Sue, please carry on.
We'll move on to Heather, who will talk you through the process for resource consents.
Kia ora koutou. So resource consent is quite small in scope. So Section 49 lays out what the deal is for resource consents. The majority of that section is about the regional council responsibilities, and we get one line. And our one line says applications to a territorial authority for resource consent for either the use of or activities on the surface of the water in the Waikato River. So it's really limited in scope. We're dealing with activities that happen on the surface of the water of the Waikato River only. So in that, Nick's explained how we get our district plan. In our district plan, we have 2 rules that deal with the surface of the water that may require you to be in the process of a resource consent. They relate to either a commercial activity or event involving a motorised vessel, or where you're looking to have a permanent structure. So there's only 2 matters that may put you into a resource consent application. The next bit in that section 49 is dealing with how we as the council would work with TMTB to look at those applications and how we would work together to assist applicants work out some criteria. So the next bit is about how we work together. And so if we look at those 2 rules, remember we're only looking at activities on the surface of the water. In the last 25 years, there have been 2 resource consent applications. Essentially, one was the extension for another boat for Hooker Jet, and the other one was a second boat for the Hooker Falls River cruise. So I think we've been way out here previously thinking about the JMA. In terms of mandatory, we're right back here, just on the surface of the water. We're only looking at 2 rules, and in the last 25 years, we've had 2 applications for resource consent. Any questions?
I guess that I might be going out of scope here, because I know we're talking about exactly what's mandatory, but we're talking about expanding to those extension areas, and so those 2 specific reasons for a resource consent would be different under an expanded demographic.
Correct. So today we just want to keep you focused on the compulsory matters, so you have a clear in your mind, if that was the agreement, this would be all it would include.
Right,
It has been opened up previously, and yes, the world of resource consents could be quite a lot broader in that context. But if we just keep our focus today, that compulsory wise, we're going to keep you on track with only potentially 2 rules and 1 matter being the surface of the water.
You're right, under the mandatory requirement.
Any other questions?
Oh yeah, thank you for I think clarifying that it really would have been quite simple to if we'd just stuck with the mandatory. There's not a lot to it, perhaps. That's what you're highlighting that I'm hearing anyway. Is that a question? I don't know. Say yes.
We are meant to be concentrated on the mandatory matters. The other matters will come up later. Are there any further questions from the councillors? Councillor Greenslade.
I think I'm right out of order, but I'll ask the question anyway. Just because I haven't got the catchment map in front of me, there's no power companies involved in any of this?
Yes.
So we're dealing with the surface of the water, correct? And then we're only looking at it in regards to our district plan, where we have a rule that controls it, that would put you into a resource consent. And under that first rule, it's about motorised vehicles, essentially using that. The second one, about structures, has a lot of exemptions, and within that, the power companies, the structures are exempt from these rules. So there's actually a lot of exemptions, different things, yeah. So we've got a very narrow scope, yeah.
any further questions from the floor? If not, thank you very much for making the presentation. Thank you to all the public for being in attendance and listening intently. It is important for your, if you have any questions, that you have the ability to speak to your councillors and they can ask them on your behalf if you have any points of clarity. Councillor Murch, you have a question?
Yeah, it's just around the series of workshops. So is the plan that we're going to be moving into this next briefing that's going to touch on the further compulsory matters, and then what's the plan from there, councillors?
From there, we thought we'd go into the additional matters, which might take a number of sessions. And then after that, we would, hoping to go into the effect of the new, after that we'd touch on the consultation and the requirement or not for consultation under the various bits of legislation. And then we would go to the effect of the new planning legislation on the requirement to have the JMA.
Councillor Cameron.
The Chair, just as a follow-up to that, at what stage will we have the ability to influence the content of the document potentially? Because one of the issues I had at the last triennium was that I wanted to express some feedback from some consultant planners about process and perhaps some delegation and some definitions and just make it a bit more of a robust, commercially, you know, contract law is quite important, and it's in a specialised area of law, and I'm just wondering whether or not we've had a good look at that, and will we have the ability to have a good look at that?
Yes, I think the team are looking at me. So this was a series of briefings as opposed to starting to influence or think about options and next steps. So I respect your views, and we need to build that into the process, but what we've been working through is some briefings to bring everyone, including new councillors and the public, on the journey to understand the mandatory and the additional matters before we get into options and next steps.
Councillor Foreman.
Can I just check, do we have a timeline on when these briefings will be completed and we'll be able to get into the nitty-gritties?
What I heard, I'm probably going to reiterate what the team said, but we're expecting the legislation to come through on the changes to the RMA in late June, early July, and so that is what we're expecting. We want to brief you on before we get into options.
Councillor Campbell.
Yeah, I'd just like to reiterate, like a broken record, that it is because of politics we are here. I just find it interesting that two of the politicians who are responsible for us being here don't have much to say.
Who?
Happy to respond.
Councillor Taylor.
The subject of this workshop is the compulsory matters. Nothing I've heard from Councillor Campbell, and the question has anything to do with compulsory matters. I'll leave it at that.
Thank you, Councillor Taylor. Councillor Murch.
Yeah, I just want to reiterate again that I think it's really important for us to enter into these spaces where we can have robust conversation about it, not be limited to 45 minutes on a Tuesday and then we're getting drip fed this information and then we're expected to at the end come out and get a piece of paper in front of us and make a decision. That's no way to govern. And I just want to express here that I feel for the partner, for the Tūwharetua Māori Trust Board in this whole instance, because while we're sitting here in the public having briefings on a joint management agreement, well, where's the other party and when are we going to get to hear from the other party? Because I know that we are talking about the mandatory matters, we're bringing the community along the journey. Well, cool, can we do it with the other partner, with the other the party to the agreement?
Yes, so councillors, yes, we will be arranging that time for you. We do an induction session with each of our iwi partners, and so we are talking about that process and what that looks like.
Okay, we'll conclude this session. Thank you very much for your time, to all the public for being here and being part of this. Just reiterate, the people sitting around this table are the ones that would like to reflect your points of view, so it's important you make those points of view known to them. Thank you once again. Councillors will break for